Hello everyone. Good evening. Can you all hear me? Hello, good evening. Can you hear me?
Yes, I can hear you, sir. Good evening, sir.
All right, good evening. Thank you everyone for joining in. Welcome to class. I can see we have some of our mentors that we are expecting in today's session on the call. We want to especially thank Mr. Bentex and Mrs. Potty. Thank you so much for joining. You are welcome to the JIIPCC Mentorship and Internship Program for the Patent Drafting course. We will be starting right about now. Just to quickly introduce myself, my name is Dennis Williams, and I will be moderating today's session. Our topic for today is Introduction to Patent Drafting and what beginners must know. So without further ado, right, I would just like to read our mentor's profile just for us to have an insight to the people who will be running us through today. Okay, but just before I do that, okay, let me give you a breakdown of what the structure of the class is going to look like. So we'll be taking presentations from the mentors firstly. They will be giving us their discourse into the topics for today in 20, 25 minutes thereabouts. And then after we are done with the mentors who are on call, we'll take presentations from the mentees. So please, for the mentees, I want you guys to get ready. Once the mentors are done with their presentation, we'll call you up to give your presentation on the course, on the research that was given to you. So, good presenter, please get ready. And then once that is done, we take feedback from the mentors. The mentors will speak to your slides based off of everything you guys have shared, so that they can fill in for your knowledge gaps, and they can give overall perspective to the work you have done. And then lastly, we'll be taking questions, and then we'll take pictures. That will be all. So back to the session. That is reading mentors. Sorry. Reading mentors profile. I'll be doing that right now. So first in class, firstly, we are expecting to have Mr. Rakesh Sharma. Mr. Rakesh is just having a thorough and multifaceted career spanning nearly a decade in patent analytics, drafting, prosecution for US and EP jurisdictions. He worked very closely with various engineering teams and supported their portfolios from idea incubation to innovation management. Mr. Rakesh has excellent understanding of patent law, claims interpretation, and drafting skills. As a seasoned professional, he is readily engaged with various end-to-end IP services at different levels and provides intelligent IP solutions. He emphasizes more on promoting innovation for a better world. He loves drafting patent claims, keeping all infringement perspectives in mind. Furthermore, he has a strong bent of mind towards IP automation and has sound knowledge of various IP tools and techniques that can be used to either improve the quality of IP or increasing the overall productivity. He is also an excellent mentor and possesses all the leadership qualities required for a successful IP profession. So that will be our first mentor for today, Mr. Rakesh. Mr. Rakesh is not yet here on the call, but we expect that when he's able to join in, we'll be able to get him to receive some of his insights as to what he has prepared for us in today's class. Secondly, we currently have Miss or Mrs. Sorry, please now you can clear me on that. That is Miss Potty, just Josie or Joshi. Sorry if I didn't get the accurate pronunciation of your name. Miss Potty, while working in the field of intellectual property for around 8 years with education and passion, she has developed a profound skill set in scrutinizing inventions and preparing patent application for filing in multiple jurisdictions. Known for high efficiency and management of patents portfolios, her expertise also include developing unified strategies for patent prosecution with high rates of grant of patents across jurisdictions. She has dealt with patent application of different engineering field for filing in different jurisdictions such as the US, EP, IN, and UK, being a registered patent agent that is in India. She also represents clients before the patent office in India. Thank you so much, Mark, for joining all the way from India. We are happy to have you here with us in the session. And last but not least, we have Mr. Bentex to, Polafia. So Mr. Bentex is an intellectual property law expert, consultant, and academic. He holds an LLM in intellectual property law with specializations in patent law and design law from WIPO, Turkpants slash Ankara University, Turkey. He is an alumnus of the WIPO Harvard Law School Patent X program. He is also an active member of the WIPO International Network for Intellectual Property Education. Currently, Bentex is an accredited WIPO Academy IP tutor and also lectures IP and law at the Department of Public and Private Law, Faculty of Law, Northeastern University, Gombe State. His research interest centers on digital entertainment, business innovation, and SME development, which from the basics of his ongoing PhD IP law at the Faculty of Law, Nasarawa State, Kefi, Nigeria. Beyond academia, Bentex is a literary creative artist and the principal consultant at Regal Legal Consults, offering IP advisory and legal services to innovators, creatives, and enterprise. His work with WIPO other national states and states IP offices has contributed to IP policy development, commercialization, and technology transfer in Nigeria. An award-winning IP influencer recognized by the JIIPCC Academy in 2024. Bentex has also co-led Nasara a creative initiative supporting Nigeria creatives in IP awareness and protection. His work continues to bridge the intersection of law, research, creativity, and innovation for sustainable development. He has written and researched extensively and is also the author of a new text on IP titled Intellectual Property Nexus, the definitive guide for students, innovators, entrepreneurs, and practitioners. You can find his LinkedIn profile below. You can connect with him. So that's his LinkedIn profile down below. The profiles, if I'm not mistaken, has been sent to the mentees group. So please, you can go ahead and connect with Mr. Bentex. Thank you so much, Mr. Bentex, for joining in on the call. I can see you already here. We are so happy to have both you and Miss Potty with us. So we will not be wasting any further time. We'll be going straight into the business of things. We'll be having firstly Mr. Bentex to give us an introduction into what he has prepared for us. So we'll be doing that in, I think, about 20-25 minutes, and then we would get to hear from Ms. Potty. So, Mr. Bentex, we would like to hear from you. Introduction to patent drafting, what beginners must know. Sir, what do you have for us in class?
All right, thank you very, very much. It's my pleasure to be here. Can you hear me?
Loud and clear, sir.
All right, let me start by actually greeting my co-mentors who I see Porty is already here. Porty, it's nice to meet you. I know we connected a while back on LinkedIn. And then, of course, Rakesh also, I would like to say hello. Moving forward, I'd like to say good afternoon, everyone. It's actually a pleasure to join you for this mentorship session, and I appreciate the organizers for the opportunity to share just a few thoughts with you with regards to this mentorship program. I would also like to commend all the mentees who have taken time to participate in this program that focuses on IP practice. You know, Patent drafting is not a casual skill. It's a specialized craft that sits at the intersection of law, science, and strategy. The good thing is that IP is an interdisciplinary avenue that welcomes everyone, irrespective of their discipline, which is good. So you find many excellent lawyers, law students, or even engineers or people in the sciences struggle with it at first, and many brilliant people, but struggle also with the legal side of patent. So today our aim is not just to make you instant patent drafters. I'm afraid we may not be able to do that just for this course. The goal here is to help you understand what patent drafting is, why it matters, and what foundational principles every beginner must know as far as patent drafting is concerned. Moving forward, let's begin with a simple question. Now, imagine you invent something remarkable. Perhaps it's a new agricultural machine that can process cassava twice as fast as existing machines. Or perhaps it's a new medical device that helps medical doctors detect diseases earlier. And so you go through the effort of building it, testing it, and refining it. Then you apply for a patent. But the document describing your invention is poorly written or poorly drafted. The claims are narrow, the description is vague, and competitors can easily copy the idea without avoiding, while actually avoiding the exact wordings of your patent. So what happens then? You might ask. In that situation, the invention may be brilliant, but the patent becomes almost useless. This is why experienced practitioners often say that the real power of a patent lies not only in the invention itself, but in the way the patent specification is drafted. So you have patent specifications and you also have patent descriptions as far as this is concerned. So patent drafting therefore involves translating an invention into a legal and technical document that clearly explains the invention and defines the boundaries of the inventor's rights. Once this is granted, that document becomes a legally enforceable instrument, which investors would read it, courts will interpret it, and your competitors will analyze it carefully to see how far they can operate about it without actually infringing it. Before we even begin drafting, we need to understand what qualifies for patent protection. Across most jurisdictions, of course, all of us understand, if you've done basics of intellectual property, understandably, that IP is jurisdictional. However, across most jurisdictions, three fundamental requirements must be satisfied when it comes to issues of patent drafting. And these requirements are recognized internationally, specifically under Article 27 of the Agreement on Trade-Related Aspects of Intellectual Property from the WTO, or what is rather called the TRIPS Agreement. The first requirement here is novelty, meaning an invention must be new. This means it must not have been disclosed anywhere in the world before the patent application is filed. If an inventor here publishes an article about the invention or demonstrates it publicly before filing a patent application, the novelty requirement may be destroyed. And that is why for those of us in the academics where the watchword is publish or perish, if it has to do with issues of patents, you are usually advised to hold on a bit and begin to apply first for your patent and get an acknowledgement before you push for the publication of whatever it is you wish to patent. But also understand that the whole ingredient of patent is to disclose what you can do so that the average person who has the set skill will be able to do it without allowing the person to do it. So it's like being granted kind of a monopoly. The second requirement here is inventive step. This is sometimes often called non-obviousness. And so the invention must not be obvious to a person skilled in the relevant technical field. In other words, it must involve a genuine technical advance rather than a trivial modification of existing technology. And so just imagine that we all drink from cups now. Perhaps the first person who brought the idea to have cups where we take out, we drink liquids from, had made something, a container, but it was without handle. And then someone else thought it would be good we have handles on this container so that when we have liquid contents that are very hot, we do not get scalded, or if it is very cold, it does not get too cold to handle. In fact, it has gone so advanced that I think currently I heard someone was able to patent a non-spillable cup where you could drink out of from space by astronauts. And so that's, an inventive step. The third requirement here is industrial applicability. It means the invention must be capable of practical use. Now, patents or patent law is concerned with inventions that can be applied in industry or technology, not abstract ideas. And we've had situations where a lot of people, especially within Africa, usually feel we have lots of good ideas, but you have a lot of people who come from technological advanced countries like Asia who come to look at the prototypes that we've done and then go back to their countries to replicate same and sell them back to us, which is a principle which has expanded these days to even include what they call technology transfer. Now, these principles, all that I mentioned above, are reflected in many national laws. For example, if we check out Section 1 of the Patents and Designs Act of Nigeria, it provides that an invention is patentable if it is new, if the results are from inventive activity and it is capable of industrial application. Once an invention satisfies these requirements, the next step here is to prepare the patent specification and description. The patent specification here is the document that forms the core of the patent application. What it does is that it performs two main functions. First, it discloses the invention to the public. Now, patent is based on a bargain between the inventor and the society. The inventor receives a temporary monopoly, usually in 20 years within our jurisdiction here in Nigeria. But in return, the inventor must teach the public how this invention works through disclosure. So when the patent eventually expires, the public can freely use this knowledge to come up with something better. Secondly, the specification have to define the scope of the inventor's legal protection. And that scope is primarily determined by the claims. Now, let me walk you through the typical structure of what a patent application does. Now, the first element here is the title of the invention. The title should be simple, precise, and technically descriptive. It should not contain exaggerated language. For example, instead of calling an invention a revolutionary machine for agricultural transformation, we could find another simpler term or a clearer title to say automated cassava peeling machine. This narrows down the scope to the specific thing we want to do. Now, the purpose of the title here is to identify the technical subject matter of the invention. Next comes the what do you say here? The abstract. The abstract is a short summary of the invention. Usually, it's not much words, but I think they usually advise that it should be between 150 to 50 words. And the function is to help readers quickly understand what the invention is all about. Patent databases are strewn everywhere, and they often rely on abstracts to help users search for inventions in particular technological fields. And that is the reason why this abstract is very necessary. Now, after the abstract comes the background of the invention. What this section does is that it explains the technological context in which the inventor, or rather the invention, exists. It describes the existing technology, often referred to as prior art, or you find some people saying priority art, and it identifies the problem that the invention seeks to solve. And most times, if you check and there are already things done in that field, you would most likely not get your patent approved based on just this. So prior art in this respect includes any publicly available information which is relevant to the invention. It may consist of earlier patents, journal articles, product manuals, or publicly known technologies that are available out there. because the moment you start thinking, having ideas, remember, we're all human beings and we're a product of imagination. People are thinking, people are creating, and people are doing amazing stuff out there. But let me give you a simple illustration. Suppose an inventor develops a new irrigation system that reduces water wastage in agriculture. Now, the background section might explain how traditional irrigation systems lose large amounts of water through evaporation or inefficient distribution. By describing this problem, the pattern specification prepares the ground for introducing the new solution, which that patent intends to take care of. Now, if you move to the next session, it will talk about the summary of the invention. And here, the drafter needs to provide a concise explanation of how the invention solves the problem that has been identified earlier. What it does is that it highlights the key features of the invention and explains its advantages. After this comes one of the most important parts of the patent specification, which is the detailed description. And here the invention is explained thoroughly. And this explanation must be sufficiently clear so that a person who is skilled in the art can sit down somewhere and also reproduce this invention without any much guidance. And then if the phrase of the person skilled on this art refers to a hypothetical individual with ordinary technical knowledge in the relevant field. You find us lawyers sometimes use terms, especially when it deals with matters in the court, called the reasonable man's test, the reasonable man's test. So a person skilled in the art for patent issues deals with someone who has, basic knowledge in the relevant field and could replicate same. Now, why patent requires that this disclosure must be complete enough is that it should allow such a person to perform this particular invention we're talking about without undue experimentation at all. And so if this description is insufficient, the patent may later be challenged for lack of adequate disclosure. And you find out that courts in several jurisdictions have emphasized that a patent specification must enable the invention to be practiced by the public to add to its invention or newness once the patent we're talking about expires. So you find many inventions also include drawings or schematics, and this can play a very important role in explaining in graphic details how the invention works. Mechanical inventions often require diagrams which shows the relationship between even the components. You also could have softwares which usually integrated into patents, and they may include how the system architecture works through its diagrams or flowcharts by illustrating the operational process. Understandably, within our jurisdiction in Nigeria, we do not patent software. What we do is that we copyright software. But when that software comes with a component, it may be patented. Take, for instance, you want to patent a smartwatch, but of course, the smartwatch is operational based on the OS operating system, which is the software. That is what we are talking about. After that, we arrive to the claims, the patent claims, and the claims defines the legal boundaries of the patent. Here, when courts determine whether a product infringes a patent, they focus primarily on the claims. So, for example, suppose a patent claim states that an invention consists of components A, B, and C arranged in a particular way. If another competitor produces a device containing those same elements arranged in the same manner, that competitor may have been said to infringe the patent. However, if the competitor modifies one element in a way that falls outside the wordings of the claims or its arrangement at all, the competitor may avoid infringement. This is why the language of patent claims must be drafted carefully. And claims here are divided into two categories. We have the independent claims that defines the core invention. They stand on their own and identify the essential ingredients, or rather the essential features of the invention. While dependent claims which come after, an independent claim could be could be one, could be two, but usually they are few. Then you have the dependent claims, and they refer to the back to an earlier claim and add additional features or dependent on the limitations that are earlier described in the independent claims. These claims provide layers of protection, of course. So if the broader independent claim is challenged, a narrower dependent claim may still survive, as we may have it sometimes during litigations on issues that deals with patent infringement. At this point, I would like to ask a quick question for reflection. Consider if you were drafting a patent for a smartphone battery that lasts twice as long as existing batteries. Would you write claims that only protect one specific battery configuration? Or would you try to draft claims that cover different variations of that battery technology? I would like to hear our views about it, if there are any. Anyone? Moderator, you could help us if there is anybody with their hands up. So the question again, I'm saying is, consider if you were drafting a patent for a smartphone battery that lasts twice as long as existing batteries we have currently. Would you, one, write claims that only protect one specific battery configuration? Or would you try to draft claims that cover different variations of that battery technology? What are your thoughts?
So for the mentees, please, you can indicate by raise of hand if you want to speak. But okay, someone in the chat box is saying claim that protects a specific battery configuration.
Okay. Any more thoughts?
If I were to add to the conversation, I would say I will file for every aspect of the different variation.
Okay, all right. So, well, the whole point of this question is that it highlights an important aspect of patent drafting. You see, a skilled drafter must anticipate how competitors might attempt to design around that patent and seek to cover all angles so that they make so much gain from doing that. And you know, competitors often look for small modifications that allow them to penetrate to achieve similar results without falling within the literal wordings of the claims. And so you would most likely be unable to catch them when it comes to issues of patent infringement. For this reason, patent drafting involves not only describing the invention, but also thinking strategically about future technological variations. You need to cover those areas. You find beginners often make several common mistakes in this angle when drafting patents. And one common error is drafting claims that are too narrow. What narrow claims provide is that they provide weak protection because competitors can easily avoid them to get to their goal, where they also want to patent something a bit similar. Another common mistake is the use of vague or inconsistent language. Patent claims must be precise. Even small linguistic differences could be the reason that it could affect the interpretation of a claim. Therefore, beginners may also neglect to conduct thorough prior art searches. And once you do that, sometimes they tell you, something like this is already existing, and sorry, no, we may not be able to grant you a patent because of this. Without understanding existing technologies, it becomes difficult to demonstrate novelty and inventive step. Developing skill in patent drafting requires practice, constant practice, and exposure to real patent documents. And like I said at the beginning, it's not something we would sit here and be able to do as a goal. We need to really need to do more courses on this for longer periods of time for you to probably understand how to deal with issues of patent specifications and descriptions when you talk about patent drafting. A useful exercise here is to study granted patents already. And all these are available in the International Patent Database. The WIPO has patent scope. In Europe, they also have their own database. In US, I think Europe have, they call their own ESPASnet. And you also have, US also have their own. So you need to go through all this database, understand when you have someone approach you to draft a patent document for them. So when reading patent examination guidelines also usually helps by the different patent offices we have within those jurisdictions, because they can help beginners understand how examiners assess patent application. Now, most importantly, patent drafters must work closely with inventors. You are drafting, but the inventor is the one who you are going to work with. They need to be really clear about what you want. You need to understand how their mind works as it relates to the issue you need to draft the patent about. Inventors understand the technical details of their creations, but they may not know how to express those details in scientific or legal terms. So the drafter's role here is to bridge that gap. That is what the patent drafter needs to do. As we conclude this discussion, I would like to emphasize one central point. You see, patent drafting transforms an invention into a legally enforceable asset. Therefore, a well-drafted patent specification not only explains the invention clearly, but also defines the legal territory that the inventor controls. For those of us who are joining this mentorship class especially, or beginning their journey into IP practice, mastering the fundamentals of patent drafting is an important step towards becoming effective intellectual property professionals. And a lot of people find patent quite technical, and they find it as a big problem, but I'm very sure you will understand it. People like me, myself, also didn't know anything, next to nothing about it, but thanks to JIIPCC and my LLM program, JIIPCC Talk Patent LLM program at Ankara University, where we had to deal with a lot of advanced patent courses, it helps. So I'd like to thank the organizers very much. I'd like to thank my co-mentors and to thank all the participants for your attention. I actually look forward to hearing the mentees' presentation at the end and engaging further during the discussions and question sessions. Thank you so much, JIIPCC, for this wonderful opportunity. Thank you, everyone.
All right, thank you so much, Mr. Bentex, for that very detailed in that sense, even though it was an overview, but it was quite detailed. So thank you so much, sir, for sharing your thoughts with us. You highlighted some very key details about what the mentees in this session should know, things around understanding claims, the scopes that they should focus on, areas and aspects of patent drafting that they should get familiar with. And I'm sure from everything that you have said, the mentees should be able to get some kind of insight as to what patent drafting entails. So when they are doing their further research, they know what and where to focus on. So thank you once again, Mr. Bentex. We really appreciate. I'm sure from the sides of the mentees, I want to encourage you after the session, please do well to follow through on YouTube to rewatch this session. I'm sure that there is a lot that our mentors are going to be saying that are going to be saying that is going to like really open us to what patent drafting is, at least for this first class. And subsequently, as we move further in the program, we'll be able to articulate more expressly what patent drafting entails. So we'll be moving on to our next mentor on the call. Thank you so much, Ma, for being patient with us, listening to the conversation. And we just want to call you on to join into the conversation from where we've already started. Introduction to patent drafting, what beginners must know. Thank you, Ms. Potty, for joining. We would like to give you the floor for you to share your thoughts with us on what you have prepared for us.
Hello.
Yes, hello, Ma, we can hear you.
Yes. Hi. Yes. Hi. So thank you very much for the introduction, and hello everyone. Hello Bentex. It has been wonderful hearing you and your thoughts. So I will also be talking about introduction to patent drafting, and with a little different perspective. So Bentex has given very good knowledge or overview of the business aspect of patent drafting and why it is important. I would touch more basic about the patent drafting and what goes actually into patent drafting. So if you allow, I would like to share my screen. I have prepared a small presentation for our audience.
Thank you very much, I really appreciate it.
Please let me know when my screen is visible.
Yes, it's on now. We can see us. We can see us.
Okay. Okay, so I have been given idea that the audience is university students and young professionals. So they may be knowing a little bit about patent application drafting. And I would like to build on or give clarity on a few points. So you may find some points overlapping with Bentix. So it would be a kind of revision to all of you. So that is good actually. So let us start with what is a patent. So we know that there are different intellectual properties, right? Whatever is originated in your mind is called intellectual property. And there are different types of properties, like there are trademarks, there are designs, industrial designs, then copyright, and then there are patents. So what are patents basically? So any idea with technical aspect is called categorized as patent. So if you have any improvement in existing technology, so that would be part of the patent category, and you have to go for applying to protect that idea. You have to go for applying patent. Now, what does patent do? When I get a patent, I would get right to prevent others from using, making, selling without my permission. So what does it mean? That if I want, if anyone has a patent, so I cannot use that invention without their permission. I have to take license or their permission in some form to use that invention. And as Bentex said, it is territorial right. So if you want to practice your invention in India, you have to file a patent application in India. If you want to practice your invention in US, then you have to file a separate patent application in the US, and so on. So it is territorial right. It is same for all the intellectual property assets, right? And another important thing is it is quid pro quo right. So what does it mean is that you have to disclose your invention in order to get the patent right. Like you have to tell what is your invention and how does it work. You have to give it to public in return of the grant of rights. So what are the requirement of patent? There are different requirements that has to be fulfilled in order to get a grant. So first is patentable subject matter, like also again this has been covered by Bentex. So every jurisdiction has a list of their patent eligible subject matter or patentable subject matter, and which are not patentable subject matter. So first of all, you have to see and check if your idea is falling within patentable subject matter or not. If it falls, then you are good to go. If it does not, then you may have to work further to make it patentable. Then your invention should be novel and inventive. So again, even if you want, it is a territorial right and you want protection in one jurisdiction, you have to check for novelty worldwide. So if someone, a student in university in Nigeria invents a fan, let us say fan with a light, and I am studying in university in India and I also invent a fan with a light. So I have to check whether everywhere in the world, including Nigeria, if this invention exists or not, similar kind of invention. And if it does, then I may not get a patent for my invention because my invention would not be novel. We will see an example of what do I mean by novel and inventiveness. And next is industrially useful, like it should be made or be used in industry. Again, one very important aspect as has been discussed is disclosure of full invention. So you have to disclose your invention fully as in a sense, in a way that any person of the corresponding technical background is able to understand what you have built and is able to replicate your invention. He should be he can be able to redevelop your invention just by reading your patent application. He should get idea how this would work. So that is meant by full invention, disclosure of full invention. And again, a well-defined scope, like it has been discussed, that it should not be too narrow or too broad to get the protection. Both have their pros and cons. So again, the scope would be well defined, and it would the claims cover the scope. So we will discuss that in a while. So here the importance of patent application drafting comes. Like Bentex already said, it is very specialized skill apart from any other drafting. So you have to have good technical knowledge and balance of law to get this skill. So we'll go through different parts of a patent application. So first is title. So it generally includes features of the, it should include features of invention in general terms, maybe within 10 to 15 words. So here I have taken one example. This is the title of one patent application. The title is Compact Appliance for Making Flat Edibles. So this gives us a broad idea that, okay, we are at this patent is talking about a device or an appliance that would make flat edibles. Now next comes the field. So it should broadly include the technology of invention. So one example is, again, I'm extending the above example. So the field of that patent application is, this disclosure relates generally to a food preparation machine, and particularly to appliance for making flat edibles like tortilla, crepes, chapatis, rotis, pita breads, etc. So as we can see, it is giving us a broad idea of the technology, that it is related to food preparation and which kind of food we are talking about. So flat edibles, like the examples that has been given here. Next comes the background. So this is a very important section in patent application. It generally discusses the problems or limitations in existing technology or prior art. So here we are defining a problem statement, that what our invention is trying to solve, what problems are there in the technology that has encouraged us or an inventor to develop new invention. So all the background of existing, all the limitations of existing technology would go in background. Then there can be a section of objects. Objects are basically advantages of the invention, whether it can be technical, structural, or economical advantage. For example, your invention would be simple in design, so that can be an object. Would be efficient, like efficiency has been increased, or it has become more cost effective. So all this can go into objects. Then summary is again a general description, you can say, that how what are the parts of the invention and how they are connected in very broad sense. So there are multiple ways summary section can be written. So we'll see what in further slides, what independent and dependent claims are. So summary can include only independent claims. It can include all claims or claims and advantage. It can also include different embodiments. Embodiments are basically alternatives that you may think of your invention. So you can prepare summary in any of this with any of this option. Next comes a brief description of drawing. So drawings are a very important part of a patent application, and you have to consider it to your advantage, especially with engineering related inventions. It is very helpful to see the what your machine or what your apparatus look like, right? So this brief description of drawing includes a very a small description. For example, here it is said figure 1 is a perspective view illustrating a flat edible making apparatus according to one or more embodiments. So here it is a perspective view of the apparatus. So this explains what figure 1 is saying in briefly. Right. Then it comes detailed description. This is a very important part of the specification along with claims. Of course, claims are important, but detailed description is equally important, because here we are explaining what is the invention actually. What type of embodiments or alternatives are there, how all the parts are connected, how it is working. So all these things go into detailed description. So it basically gives enablement. Enablement is, like I said earlier, it should, if any third person of that technological field is reading a patent application, they should be able to recreate that invention. Right, without much of research. So it should, your detailed description should be very clearly written, so that your invention comes out very clearly without any ambiguity. If you have experimental data, you can add. And I think you all know claims are very important, because based on that only the scope is decided of your invention. So it should not be very narrow, and it should not be broad as well. So every patent application must include one independent claim. Independent claim is basically a main claim that would talk about what you are protecting, or that would talk about what which type of right, a protection right you would get when you get a patent grant. So independent claim includes all essential part of your invention, and then there are dependent claims that would extend features or additional features of your independent claim. And abstract again is general summary of the invention with advantages, use of invention, etc. And again, as I said, drawings are very important part. So it we can say image, we can recollect, or image speaks 1,000 words, right? So you can get an idea just by looking at the drawing what you are talking about, and when you read it with description, it makes your invention clearer. It is easy to validate, it is easy to fight in case of any suit or etc. So drawings are again very important part of patent application. So this is these are the different parts, and what all goes into the parts. So this is an overview of a basic patent application and how we should write it. Now let us talk briefly about claim and what are different parts of claim. So claim generally include three parts. First is preamble, then next is transitional phrase, and next is body. So when you would draft a patent application on your own, you would be drafting in this manner. So here is an example. So it would be clearer to you how you can go with drafting a claim. So preamble basically gives an idea about what your apparatus is, what your invention is, and what protection for which type of technology protection you will get. So here an apparatus is a preamble, then comprising is a transitional phase that we will talk in a bit, and we'll talk about in a bit. And next is body. So body is includes the features of your invention. So here we are talking about an apparatus that comprises a pencil having an elongated structure, including two ends and a center between the ends, an eraser attached to one end of the pencil, and a light attached to the center of the pencil. So here I have said what is my invention and which parts are there and how these parts are connected. So this is an example of one independent claim. And there can be different type of claims. So there can be a process and a method claim, and there can be device, apparatus, system, assembly, or composition claim. But the structure of claim or parts of claim would be the same, whether it is a process claim or device claim or composition claim. Preamble, transitional phrase, and body should be there to complete a claim. We'll talk a little bit about a transitional phrase. So there are two types of transitional phrases. One is open-ended and one is closed-ended. So in open-ended, what does it mean by open-ended is there is provision of additional features. And the examples are comprising, having, including, etc. So if we see in this example, we have used comprising as transitional phrase. What does it mean is my apparatus is having these three essential features, but it can have additional feature, for example, holder, a pencil holder. So the term comprising would help me here to have additional feature apart from these features of body of independent claim. And next is closed-ended phrase. So in that, no provision for additional features, and example is consisting of. So if I have used here an apparatus consisting of a pencil, eraser, and light, so I am binding myself to these three features only, and it means that my apparatus cannot have additional features. So in practice, generally open-ended phrase is used. So comprising or including or having is used when you have practiced, when you will practice or you already have, you would have noticed these phrases frequently. So again, here is an example of one independent claim and one dependent claim. So the example is an apparatus. It is the same example that we saw. Apparatus comprising pencil having elongated structure, including two ends and the center between the ends, an eraser and a light. So this is one independent claim. And because here I have used comprising, I have used comprising, so it is open-ended. I can have more features. And the second claim is dependent on claim one, wherein it says that said eraser is detachably attached to the pencil. So what dependent claim is doing is it is giving specifics of the eraser, how this erasable is connected to the pencil. So it is detachably attached. So additional feature or specific, more specific feature of eraser is given. So this is how dependent claims are drafted. It elaborates or give additional features. This is one example of novelty. So here we can see what does novelty, what is actually meant by when we say an invention is novel or not. So here on the right hand side we have image of a chair, and our first example is a chair comprising a seat and four legs. So this is my claim, that I am claiming a chair comprising a seat and four legs. And this is a second example, which says that a chair comprising a seat, at least four legs, and a handstand. So in these two examples, you can see that in the second example, a handstand is added here. And instead of four legs, like sticking to only four legs, here the claim says at least four legs. It means that it can have more than four legs as well, like 5, 6, 7, etc. And additionally it has handstand. So you can see this claim is novel over this claim. Even though it has seat and four legs, it is novel because of this handstand. So this is how novelty is checked. Each feature is each feature of claim is compared and seen if your claim is novel or not based on additional features. And this is one example of inventiveness or non-obviousness. So I have a prior art as in already existing patent application or patent or a disclosure in public domain, which says that a chair comprising a cup holder to hold coffee cups. So this is the invention that is claimed in prior art application. And my claim includes a chair comprising a holder to hold water bottles. Now we can see that this claim is talking about holding coffee cups, and this claim is talking about water bottles. But is it obvious? Is it a novel? Yes, in a way we can say it can be novel, but is it obvious? Yes, it is obvious. So even though the depth of the holder may be different for water bottles, there may be more depth in the holder uh, as compared to the holder of coffee cups, but it is obvious, right? So it is not inventive. So this is how inventiveness is checked of your invention. So previously we talked about a non-patentable subject matter. So every jurisdiction has a non-patentable subject matter. More or less, they are similar and they go hand in hand. So for example, in India, sections 3 and 4 of Patent Act talks about patentable subject matter or which are non-patentable subject matter. In US 35 USC 101 talks about patent eligible subject matter. So anything that is not in these four categories, that is process, machine, manufacture, and composition of matter, are not patent eligible. All these four are patent eligible subject matter. And in EP Article 52(2) talks about non-patentable subject matter, that is discoveries, scientific theories, and mathematical models, aesthetic creations, schemes, rules, and methods for preparing mental acts, playing games, or doing business, and programs for computers. So these are non-patentable subject matter or patent eligible subject matter. So when you draft a patent application, you have to be very careful not to fall within non-patentable subject matter. With nowadays inventions related to AI, there are many chances that inventions go into programs for computers, or in some cases, mathematical methods. So you have to be careful to keep your or to draft your application in a way that it should not fall within these categories to get patent. So it should anyway address technical problem, and it should provide a technical solution while avoiding these categories of invention. This is very general additional information about the patent applications. So in India, when you file a patent application, you can file with 30 pages and 10 claims. In US, you can file a patent application with 50 pages and 20 claims, in which you can have 3 independent claims and remaining dependent claims. And in EP, you can have 35 pages and 15 claims. Of course, you can have additional pages and additional claims, but you have to pay additional charges beyond these numbers in every jurisdiction. Okay, so here I have an example of a patent application. I would like to show you what we discussed and how does this patent application look like. So this is a granted patent of US, and this is the title that we talked about, compact appliance for making flat edibles. These are bibliographic information that patent office takes care of these. Then this is abstract. So a brief summary and use of invention. It says that this patent has 20 claims and 12 drawing sheets. So we can see here drawings like we saw perspective view of the apparatus. So different views are there, different components, how each how at each level how the apparatus work, individual components and connection between them. You can see how detailed the drawings are, and just by looking at drawings you can have a very good idea about how this machine would be working. So as I said, it is important to have drawings very clear and precise. So after this drawings, we have field of invention. Then we have background here, background of invention. This briefly discusses the prior art. Then summary of invention. This discusses the invention in brief. Then brief description of drawing and detailed description. So detailed description generally includes explanation of figures that we have included with the for providing better clarity. And at the end we have claims, and in this application there are 20 claims with one independent claim of single compact apparatus. All right. So with this, I am done with my part of the session, and I hope I have increased knowledge and value. And yes, if you have any questions, we can discuss. And I hear that there is one exercise also. So I am eager to see what is that. Over to you, moderator.
All right, thank you so much, Ms. Potty, for such a very detailed presentation, just giving us a very standard description of what patent drafting is, what patent drafting is, aspects and areas, different areas of patent drafting. Thank you so much, ma'am. We sincerely do appreciate. So we'll be taking presentations from the mentees. The presentation is supposed to capture their research into the topic. So over the week before the start of this class, we usually do give out presentations for them to work on to have an idea of what will be discussed in the session. So please, for the presenter in today's class, you can go ahead, unmute, introduce yourself while I help you share your slides. Thank you.
Okay, good evening, sir. Good evening, everyone. Am I audible?
Yes, you are audible. We can hear you.
Okay, thank you very much, sir. My name is Bernice Izain, and I'm the group leader for this week, and I'll also be taking the presentation for today.
Oh, Dennis, can you see my screen?
Okay, I can't see it yet. I can't see it.
Okay, so I have two device currently showing, so I can see it on mine. Please, can we have someone else confirm if they can see my screen? Any of the ministers, can you confirm if it's from my end?
Yes, I can see your screen, so.
Okay, I can see it.
Okay.
I can see it.
Yes, okay. So Dennis, please go ahead and
Okay.
let me know when you want to move to the next slide.
Okay, sir. So, first off, I would love to thank our speakers, Mr. Bentex Tolafia and Mrs. Potty, for their amazing presentation. I've learned so much. And for my presentation today, it's just going to be a summary of everything that they have said. And it's also a summary of what the group members, what we have put together. So I'll basically be repeating it maybe, but this time it will be different because the examples are quite different. So the first slide, that's the introduction to patent drafting. The next slide, please. That's the meaning of a patent. Okay, so a patent is an exclusive legal right granted by the government to an inventor, which allows the inventor now to make, sell, and use the products exclusively. So it's not just any kind of right, it's an exclusive legal right that is given to an inventor. And this right, it rewards his creativity or his invention. So for example, now if I produce a new type of water bottle, I can patent it. That is, I'll prevent others from selling it, using it, or producing it, so that I'll be able to make profit from it. So that's the purpose of a patent. And it also encourages creativity and allows for technological advancements. So the second slide now is the first patent that was ever granted, and that was in the year 1421. Yes, and I would love to thank the person that organized this presentation, that's this PowerPoint, because she was so gracious to include the picture. So if you look at the picture right now, that's an example of the Filippo Brunelleschi Dome of the Florence Cathedral. This was created in 1421. It was given the person that designed the drafts for it. Now he was giving patent to it because he used a different kind of system in building this. It was called the herringbone bricklaying, and this form of system, it did not require any form of wooden support. I think at the time, whenever they were building a very big building, and not maybe a home or any kind of building, they would require to use a form of wood to hold it in place while they are building. But this particular cathedral now, they had a different system. That's the person that designed it had a different system whereby it's they were able to build it inward and outward. I'm not a builder, I can't really explain it here, but it's quite different from what was obtainable at that time. So he got a patent for this particular cathedral, and even up to date, it's still the biggest cathedral in the world. Yes. So next slide, please. Okay, next slide. So the next slide is the criteria for patents, and we have highlighted three criteria for a patent. The first is the novelty, second is the inventive step, and third is the industrial applicability. So I'll explain this in the order I've said it. So firstly, novelty. Novelty means something that is new, and for a patent to be granted, it requires that that particular invention must be new. That is, it must not have been existing already in the body of public knowledge before that patent application is being filed. That if you are producing a new product, that product should not be existing already. It should be something new, something that nobody has ever seen. For example, the person that patented a vacuum cleaner that did not have a bag. Okay, let me start the exam. Okay, so a vacuum cleaner usually has a bag whereby if you suck in dirt, the dirt will go into the bag. So this particular person made a vacuum cleaner that did not have any form of bag. So it was a new kind, and he was able to patent it. I think it was called the bagless vacuum cleaner. So that's an example of something new, something that has not been seen before. And secondly, inventive step, that is non-obviousness. That is, it's a technical improvement wherein the steps involved is not obvious to a person that is skilled in that field. For example, I use an earlier example that if I can produce a new kind of bottle, and what I'm producing now is obvious to the person that a person that is skilled in that area, that's a person that can produce bottles, then I cannot be granted patent. I think the example of one of our mentor, Miss Potty, she spoke about a chair that had a handle that could hold coffee or drinks. So is it obvious to a person that can make a chair? If yes, then you cannot patent it. That's just the example, the best example for an inventive step. So another example is what Apple. I think Apple patented the touch we use on our phone, like ability to use touch screen. Yes, I did not confirm that, but I saw it as an example wherein the touch aspect of phones or laptop has been patented by Apple, and that's a major improvement or an invention in the world of technology. So thirdly, industrial applicability. The invention must be capable of practical use in the industry or business and not merely theoretical. So that's just as simple as it sounds. It must be practical, not theoretical. For example, a new solar panel that is capable of generating electricity more efficiently would satisfy these requirements. Or for example, when Hawaii is updating their products, they are making their battery stronger. It can last for maybe 2 days now without having to charge it. That's something that can be applicable. It's not theory. Like we can actually like see it happening. It's very practical. So those are the three criteria required for patents. Firstly is novelty, secondly, inventive step, and thirdly, industrial applicability. So the next slide, please. Okay, so the next slide, that is the types of patent application. So we have two types of patent application. So firstly is the conventional patent, and secondly is the non-conventional patent. So for the conventional patent, this is a form of patent that is granted to a person, and that patent has already been granted in other countries before. Let me give you an example. It's a patent that has already been registered in a particular country before it is being filed in another country. Perhaps you have this patent granted in the UK or in the US, then you're applying for patents in Nigeria. That is a conventional patent. So if a company first files a patent in the UK and later files the same patent in Nigeria, while maintaining the same priority date, it becomes a conventional patent. And this process is actually supported by Patent Cooperation Treaty and the World Intellectual Property Organization, wherein if you have created a product in a particular country, you're allowed to file for application and to file application for patents in other countries, and you'll be granted based on the priority that you have in the country that you patented it first. Then the second type is non-conventional patent. So this is quite just very normal. Is the first registration of invention in a particular country, and it does not rely on foreign priority. Like that's the first time that particular product or invention is being patented. So the next slide, please. Next slide is the importance of patents. So there are several importance of patents not just in Nigeria, everywhere, because if a person now produces or brings about a new innovation, what okay, the importance basically is just I see it as a form of encouragement to people that are innovators. Now, why should they patent? Why should they produce a new? Why should they think or struggle to produce something new, something that can help people to live their lives easier? So one of the importance of patents now is the protection of intellectual property. And this patent grants inventors exclusive right to make, sell, use, or even license their products. For example, we have the case of Amazon Inc. versus Barnes and Noble. So for Amazon, you know that is the website that you can buy things on Amazon. So they had a technology whereby you just click, and once you click, you can buy the products, like just a one-click system. So formerly, the way it was, they had several clicks whereby you have to put in you have to fill in different things like your address, where you want it to go to, what your name, this. So it takes time before you're actually able to buy a product, and you do it every single time you want to buy a product. So they thought that okay, they can make this easier by just having that one-click method, because for um for most buyers now, they don't really change their address so often. So they had that one-click buy system where if they go in, you can just click once and you're able to buy the product. So Barnes and Noble incorporated that in their own company, and Amazon sued them now because they had already patented that one-click system. But strongly speaking, because Barnes and Noble is saying that there is something obvious to them. So at first it was ruled in favor of Amazon. Then after some time, when they appealed, it was ruled in favor of Barnes and Noble again, wherein they even had I think that was a two-click system before they saw Amazon one click and incorporated this. But at the end of the day, the case was settled outside, like out of court settlement. So you don't know the conclusion, but this is an example of how you protect intellectual property. Wherein if you patent your work and you see somebody's using it, you can actually report and appeal so that you can get some form of compensation or can stop the person from using that particular product. So secondly, incentive for research and development. So what this means is that if you are allowed to, if the just like you're allowed to patent now, so companies will be encouraged to invest heavily in innovation, because they know that that price they're paying for investments, they can recover it back when they patent that particular product. So pharmaceutical companies like Pfizer, if you that's Pfizer, they are very popular for producing so many kinds of drugs. So now they invest a lot, they invest billions in developing drugs because at the end of the day, they patent those drugs and they're allowed exclusive sale. Okay, I did not mention it earlier. The time limit for a patent is 20 years. So you have that entire 20 years to yourself, producing, selling, and having the license over the product. Thirdly, promotion of economic growth. A strong patent system attracts foreign investment, industrial development, and job creation. For example, countries that comply with the intellectual property rules of the World Trade Organization, that's WTO, under the TRIPS agreement often attract more technology-based companies. That this is not far-fetched. Look at companies in the UK or in the US, you can see that they attract more investors like countries like Nigeria because now they have so many innovations going on there, people inventing things there every single time. Meanwhile, I did intellectual property in my 400 level, and my lecturer, the professor, told us that the problem he has in with Nigeria is that we do not produce new things, and I have to agree with that. If we were producing more things, it's easier to attract investors to come because of that value you have. I think it was good that they bought a particular company, I think a Motorola company, because it was patented. So that's one of the ways you can generate funds too, by patenting your work and selling it to the highest bidder. So fourthly, it encourages technology transfer. So patents allows investors to license their technology, I said this earlier, to other companies, and encourage global sharing. So now because of this system, we get to have new products or learn new things. For example, now we have let me say cars, or we have blenders, or these little equipment that have been patented and makes life easier. So it allows for knowledge sharing across the globe. So fifthly, public disclosure of knowledge. So patent law requires, this one is not optional, it requires inventors to disclose how their inventions work. So it helps future innovators to improve on existing technology. I think this was said by our first speaker, Mr. Bentex, where he said that um detailed description must be given to allow for reproduction. That is, must write down the way and manner the process you followed in coming up with that product, so that somebody else can use it and produce the same thing or even improve upon it. Because for example, like now, if you had no blender in those days, it would just maybe blend things that soft. Now we have food processors, we have juicers, like they can blend or grind very strong greens. Now they can even produce they can get the juice out of fruits, and they can serve other purposes. So that's the kind of thing that's what it encourages, allows for that public disclosure of knowledge. When you allow it, people can work upon it, look at the gaps in it, and improve on that particular product. And sixthly, promotion of healthy competition. So although patents grant temporary monopoly rights, that's for that 20 years period, they also push competitors to develop alternative innovations. For example, this is very practical example. What usually happens every single year between Apple, Samsung, Hawaii, Techno, Infinix, all these phone companies, you see that every single year they're producing a new kind of phone. I think it was iPhone. I don't know if it's 17 or 18. I don't really follow it, but every year iPhone produces a different kind of phone with a higher upgrade. And the same thing with Techno. Every year something new is coming out. So they just upgrade it and release a new phone so that it's better than their competitors. So this form of patent allows for healthy competition amongst them. Then the seventh point, strategic business advantage. So patents are valuable business aspects as they can increase the company value. I said this earlier, they can attract investors. I also said this, they can be licensed and sold. And an example is that Google acquired Motorola Mobility. That's one of the main reasons why Motorola extensive patent portfolio had increased. So in conclusion, patents play a crucial role. Okay, this is not included in the slide. They play a crucial role in protecting innovations, encouraging research, promoting economic growth, and advancing technological development. And understanding patent law is very essential for law students, lawyers, inventors, those that are researching, those that are into business and innovation driven industries. So thank you so much for listening. Okay, we have questions at the end, which are provided. Yes. I think the next slide, yes, the questions
Yeah.
there.
All
It
right.
has been included. I saw it this evening.
Yes.
Yes.
Thank you. Thank you, Benny, so much for a wonderful presentation for you. Well done to you and to your team for putting it together. Thank you for stepping in on behalf of your group to make your presentation. So what we'll be doing now is that we'll be taking feedbacks from our mentors. Unfortunately, Ms. Potty has dropped off from the call. The time difference between here and India is about 6 hours, so I understand it is quite late over there. So I'm sure it is for that reason she couldn't continue with us. But we still have Mr. Bentex with us. Thank you so much, sir, for staying on the call. I'm sure you had the presentation from the group, right? So we just want to hear your thoughts on their presentation and maybe anything you would like to share. And also, if you can also address the questions that they have, we would really appreciate that, sir.
All right, thank you very much. Can you hear me? Can you hear me,
Yes, sir, we can
please?
hear you.
All right, thank you
Yes, sir,
so
we can
much.
hear you. We
Thank you
can hear
very
you,
much.
sir.
Thank you very much. I'd like to, even though Pot is not here, to thank her in absentia. And that was a good presentation, Bernice, on behalf of your team. First, let me commend your team, you and your team, Bernice, for making the effort to put together a presentation on patent drafting. You know, I wanted to tell you, hold up, when you had mentioned it's good for lawyers, law students, why are you excluding others now? IP is for everybody. It's not just for law students, lawyers. I think it's open field. In fact, I was really, what's the word to use? I was really surprised when during my LLM program at Ankara University, sponsored by JIIPCC, I discovered that more than half of my class, it was an LLM program, but more than half of the class were made up of engineers, medical doctors, pharmacists, people from the sciences. Anyway, patent law can be quite intimidating at the beginning and so abstract, actually, because it involves both legal reasoning, scientific issues, and technical thinking. Now, the fact that you attempted to explain the basic concepts already in your presentation already shows you are engaging the subject in a serious way. Now, if you would allow me, let me highlight a few strong points in your presentation before offering some suggestions for improvement. One positive aspect in your presentation is that you started with the basic definition of patent, which is good. This is always a good entry point. Understanding what a patent is helps frame the entire discussion. As you rightly noted, a patent provides protection for inventions and technological advancements for a specific period of time, usually 20 years from the filing date in most jurisdictions. Now, this principle is recognized internationally under Article 33 of the WTO Agreement on trade-related aspects of IP rights, the TRIPS. Another good point in your presentation is that you identified the three core requirements for patentability, which we discussed before, both Potty and I. That is novelty, inventive step, and industrial applicability. These are indeed the foundation of patent or patent law. In Nigeria, these principles are reflected under Section 1 of that an invention must be new, must result from inventive activity, and must be capable of industrial applications. I also appreciate that you attempted to include historical context by referring to the early patent associated with the Florentine architect, Filippo Brunelleschi. That is an interesting example because it reminds us that the idea of rewarding inventors is not new at all. Historically, patent privileges were granted by rulers to encourage innovation and economic development. Now, let me offer some observations that may help strengthen your future presentations. The first issue concerns clarity and structure. Some of the slides, that is for me, this is my opinion, though appear incomplete or difficult to follow. For instance, the slide titled Importance of Patents seems to lack explanatory content. That may be deliberate, but I think I got your explanation. So when preparing slides, it's actually quite important that each slide communicates a clear idea. A useful approach is to think of each slide as answering one question. For example, what is a patent? Why are patents important? What are the requirements for patentability? What are the types of patent applications? These are things I expect your slide to deal with. The second point concerns terminology. I noticed the slide title, Types of Patent Application in Nigeria, which listed PCT or conventional patent, and then the one that talks about non-conventional patent. I think it will be more accurate to describe them as national applications, conventional applications based on the Paris Convention, and international applications filed under the Patent Cooperation Treaty System, the PCT system, administered by the World Intellectual Property Organization, WIPO. Nigeria here participates in the PCT system, which allows inventors to file a single international application that can later enter multiple national jurisdictions. However, let us understand that it is important to understand that the PCT does not grant a global patent. It simply streamlines the filing process across multiple jurisdictions. Now, the third observation I have relates to depth of explanation. Your slides mention key ideas such as novelty and inventive step, but to help your audience if you provide simple practical examples. For instance, imagine someone invents a new type of solar-powered irrigation pump. If a similar pump has already been described in a prior patent or scientific publication, then the invention is not novel at all. If the invention is merely a minor modification that any engineer could easily make, then it may lack an inventive step also. But if the invention introduces a genuinely new mechanism that significantly improves efficiency, this may satisfy both requirements. So providing examples like this makes technical legal concepts easier to understand, especially when we discuss issues of patent. Another suggestion concerns your presentation design. I love it, it's fine. However, I noticed some slides contain several typographical errors. I know we are talking about patent specifications, patent descriptions. Understand that one mistake you make in your patent specification is going to defeat the purpose of that document. For instance, check page 2. I discovered you spelled subject there as sublect. I know it's a typographical error. Page 2. Sublect. Down. Okay, it provides, yeah, go back. Here, I think. It provides protection to invention and technological advancements for a specific period of time, subject to certain conditions. I don't know, my eye just caught that, subject. Then you see presented by group 1. You saw the way you wrote presented. An alphabet is missing, I think E. It just came to mind. Then go to page 5. Hello, if you can hear me, go to page 5. Are we there? I can't see the slide moving. Yes, page 5, no? Yeah, here. So types of patent application in Nigeria. So that's a typographical error where you have double E. It also caught my eye. Now, this may seem minor, but accuracy, remember, is very important in legal and professional presentations. Patent practice itself requires very, very precise drafting. So developing the habit of careful proofreading will help us greatly. Now, let me address the 2 questions you raised, because they are very good questions, actually. Your first question concerns disclosure before filing. In most patent systems, if an inventor publicly discloses the inventions before filing a patent application, the novelty requirement may be destroyed. Nigeria follows a relatively strict approach on this respect. If you check under section 1 of the PDA, an invention must not form part of the prior art before the filing date. Therefore, premature disclosure can be risky unless it falls within certain limited exceptions recognized in patent practice. Your second question about the first to file system is particularly also insightful. Nigeria indeed operates a first to file system, meaning that the first person to file a patent application generally obtains the rights to the invention. This system is widely used globally because it creates administrative certainty. However, it can sometimes disadvantage small inventors who lack immediate access to legal or financial resources. This is why many scholars argue that developing countries should strengthen support structures for inventors, such as university TTOs, that's technology transfer offices, innovation hubs, and affordable IP advisory services. These mechanisms help ensure that talented inventors are definitely not excluded from the patent system simply because they cannot file quickly. Overall, I believe your presentation is awesome and it shows that you understand the basic foundation of patent or patent law. With some improvements in structure, clarity, and examples, your presentation will become so much stronger and amazing. But let me leave you with one final thought though. Patent drafting is not merely about writing a document, it's about transforming an invention into a legally protected asset. So when a patent is well drafted, it can attract investors, support technology transfer, contribute to, they're talking these days of IP financing or IP collateralization, as well as contribute to economic development. So I encourage you all to continue reading patent, to continue doing what you do in IP, continue asking questions, and most importantly, continue practicing. Thank you so much for the effort you've put into this presentation. It's amazing also. Thank you.
Sorry, please. Hello, can we all hear me?
Loud and clear, sir.
Yeah, sorry, my network got disconnected, so I'm just trying to get back on track. Thank you so much, Mr. Bentex, for your feedback on the presentation and also for helping us go through those questions. So those were two questions from the mentees after their research. We would still be taking live questions in the session. So please, if you have a question you would like to ask in the session right now, please go ahead and indicate by raise of hand. You've listened to everything the mentors have shared. If you have questions, please do by indication, by raise of hand, or you can send your questions to the chat box. And I'm sure Mr. Bentex is really, really, really much available to help treat or address your questions. So please go ahead and ask questions. Do we have questions in class? Let's take advantage of the presence of our mentor. I'm sure during the research you may have come across one or two things, and even listening in class, right? You may have come across, you may have had something that may not have been, what's the word I'm looking for? You may not have understood, right? While Mr. Bentex or Ms. Potty was sharing. Let's do well to ask questions if we do have questions. Okay. In the absence of any question, I personally would want to ask a question. All right. Just coming from the overall knowledge of intellectual property and particularly under copyright, we know that in other certain instances, right, if for instance for instance somebody's work has been pirated, right, the person is being charged, the person can claim fair use as a means to escape whatever consequence that may come up with copying another person's work, right? So I don't know if that's that is something you can find in patents, where maybe, for instance, someone who copies an invention, right, but claims that he's not using it to generate any monetary value. Would that person still be held accountable for copying another person's invention? That's my question, sir.
All right, thank you very much for that question. First, even though you brought this from the aspect of copyright, piracy generally refers to the unauthorized reproduction, distribution, or commercial exploitation of a copyrighted work. And what it does is that it typically involves activities such as illegal copying of books, films, blah, 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 all those things that deals with copyright. And these acts directly interfere with the exclusive rights granted to the copyright owner. Now, piracy usually violates this rights, looking at it with the respect to bringing in fair use. Fair use is a limited legal doctrine, and what it does is that it permits certain uses of copyrighted works without the permission of the owner. But when you look at this critically under Nigerian law, for instance, fair dealing may apply for purposes such as for research or private study, for criticism or review, reporting current events, educational use. However, even within these categories, the use must be reasonable and must not conflict with the normal exploitation of the work. So therefore, if someone pirates a movie, book, song, or whatever that deals in copyright and distributes it online or sells copies, that act would almost certainly fall outside fair dealing, and the person will remain liable for copyright infringement. So in practical terms, fair use or fair dealing is a shield for limited socially beneficial uses of copyright works and not a defense for piracy. When you relate this in terms of patent, like you asked, the short answer is no. The concept of fair use does not exist in patent at all the way it exists in copyright law. Fair use is a doctrine that is associated with copyright. But what patent does, or patent law does, is that it operates very differently by granting the inventor the exclusive, underlying exclusive right to prevent others from making, using, selling, offering for sale, or importing the patented invention without any authorization whatsoever. And these rights are recognized internationally or globally. Look at the WTO TRIPS, look at other national legislations like the PDA that we have here. And because patent protects functional inventions rather than expressive works, the legal system does not generally allow people to use patented inventions freely under a doctrine like fair use or anything at all that deals with copyright, on the other hand. However, patent does recognize limited exceptions or defenses, though they are not called fair use. Examples you could use here are experimental or research use exceptions, which is a defense in some jurisdictions. You also have private and non-commercial use. You also have regulatory use exceptions, which sometimes people call the BOLA exception. And then you have the compulsory licensing that mostly is used in a pharmaceutical patents, where in special circumstances, governments may allow third parties to use a patented invention without the consent of the patent owner, subject to payment of remuneration, because it's usually not free. And particularly this compulsory licensing is accepted under, if you look at Article 31 of the WTO TRIPS. Look at what happened during COVID-19. And a lot of it was an international disaster. People were dying like flies, and then pharmaceutical companies were working around the clock to provide medicines to take care of people, populations, and because it couldn't go around, but there were people with capabilities to mass produce this, but they were not licensed. And they had not patented it. But government granted them compulsory licensing to pay those people who had those patents and then to reproduce so that more people will be saved. So while copyright has a fair use or fair dealing, patent deals with specific statutory limitations and exceptions. This is just what I can tell you with regards to your questions. I hope this clarifies issues, sir. Thank you very much.
Yes, it does. Thank you so much, Mr. Bentex. All right. So if we don't have any questions, in the absence of any questions from the mentees, any further questions from the mentees, we would want to say a big thank you to Mr. Bentex and Miss her name has skipped my mind right now. Miss
40.
Miss Potty, yes. So we want to thank both of them for helping us run through today's class. So just before we go, right, my network just logged me out from my other device, and I'm not very certain I would be able to turn on my video on this other one. So please, can we just, for those who have stable network and you can, please turn on your videos. Let's take a quick picture of the class today to just notify that you were present, and for our social media posting for some of us who will be posting, right? Yeah, so let's do that quickly. Thank you so much. It's nice seeing you, Mr. Bentex. Chini Ivy, sorry if I'm not pronouncing your name very well. Nice also seeing you. Let's do that. We'll be doing that in, I think, a minute. All right, so we are done. Thank you very much, everyone. Thank you so much for showing up to class for to the mentees. All right, we would go again next week. This is just the first class, and it's basically introduction to the session, is introduction to patent drafting. There is more that will be covered in subsequent classes, and I hope we are going to be available to follow through and to ensure that we gain as much as we can from the mentors who will be coming to share their thoughts and knowledge with us. Once again, a big thank you to you, Mr. Bentex, for sharing your thoughts with us. You have greatly enriched us in that sense of knowledge that we may not be able to find everywhere or anywhere. So thank you once again, sir. For the mentees, do not forget to share what you have learned on your different social media platform. You can tag Mr. Bentex. His LinkedIn address is on his flyer down below. You can check it, right? And then connect with him. And I'm sure if you have questions you would like to ask, you can do that through LinkedIn. So thank you everyone for coming to class today. See you all next week and enjoy the rest of your evening. Bye-bye, everyone.